Good evening, everyone, and a very warm welcome to the Connecting Voices panel discussion, a space where we go beyond policies and procedures to explore the real world challenges of creating safe and respectful workplaces. When I started this panel series, my goal was simple: to bring together POSH practitioners, industry leaders, and frontline change makers to share their insights, confront tough questions, and inspire fresh thinking. Because when we truly listen to each other, we don't just solve problems, we prevent them. Building on the success of these series last year, this year's Connecting Voices series continues to delve into various aspects of the POSH Act and beyond. For those of you joining for the first time, I'm Yamuna Chingappa. I've been working as a legal consultant for 20 plus years and currently serve as an external member in the internal committees of leading organizations and few NGOs across India. Over the past decade, I've handled more than 350 POSH inquiries, including deeply sensitive and complex cases, and conducted over 1,000 awareness sessions in English, Kannada, and Hindi. My intent is to make complex ideas accessible and to empower people to ask the right questions. Now, in our previous panels, we explored topics like role of a presiding officer under the POSH Act and POSH compliance in the startup ecosystem. Today's panel discussion is very interesting. It's POSH cases and courts, insights and challenges. It seeks to unpack key judicial trends, landmark rulings, and recurring challenges that arise when POSH cases are tested before courts. It aims to bridge the gap between IC processes and judicial expectations, enabling organizations to build legally robust and defensible inquiry mechanisms. I'm delighted to have with us an esteemed panel of experts who bring rich experience from litigation, advisory, workplace investigations, and organizational compliance. Let me now introduce our first panelist, Ms. Purna Ravishankar. Purna is an advocate and researcher with the Alternative Law Forum, Bangalore. She is currently working on a constitution literacy program that aims at taking the values of the Indian Constitution to common people. She also works on different issues related to gender-based violence. She is closely involved with the sex workers collectives in Bangalore that looks at the issues of police violence. She has conducted gender sensitization programs for the Bangalore City Police. She serves as an external member on the ICs of different organizations and also regularly conducts POSH trainings for different institutions and organizations. I would. Our other panelist, thank you. Our other panelist is my colleague and Sashite, Soumya Bhatt. Soumya is a co-founder of Sasha. She is an advocate practicing socially conscious lawyering in the courts of Bangalore for 27 years. She has worked on property rights, family law, contract law, intellectual property, and the rights of the urban poor. She has also conducted gender sensitization sessions, legal awareness programs, sessions on diversity and inclusion over the last 2 decades. Soumya is a consultant specializing in preventing sexual harassment at the workplace since 2007, supporting the public sector, private sector, educational institutions, and NGOs in this area. She has also been litigating in appeals under the POSH Act. A very, very warm welcome to both of you. So without losing much time, let's start today's discussion. Let's begin by understanding why so many POSH matters eventually reach courts, despite organizations having internal committees in place. So Purna, from your experience, what are the most common reasons for this? Is it dissatisfaction with the outcome, lack of trust in the neutrality of the process or the committee itself, procedural irregularities, or is there like gaps in documentation and communication?
Thanks to Sasha and the whole team for organizing this and thinking of me when you were trying to put the panel together. Yes, when we look at POSH litigations, I can think of a few reasons that we've encountered, one of which you mentioned also, which is that often either the respondent or the survivor feels like the IC has not done an impartial job. And they feel that the IC from the get-go has taken the side of either the respondent or the survivor. So this question of confidence is often something that, takes a case to the courts for litigation, and also bad inquiries, because in our own experience we have seen that documentation is something that ICs do not spend time on, and one, because they don't know how to document things, and two, also because they feel that it is not such an important thing. You just get a case, you do an inquiry and finish it, and you go on with the company's other work. That is another reason why we see litigation going to courts. The other thing, which is slightly far more concerning, is we have seen instances where the survivor has not known where she's supposed to file her complaint. Is this complaint, does the IC have a jurisdiction? Am I supposed to go to the LC? Many people don't even know what the LC is. Where are you supposed to find this office? So we've seen that in a lot of these cases, the survivor has already done like a full round. They have finished the inquiry, and then when they feel that the IC is not done an impartial job, then they try going to courts, where they're told that, look, this whole proceeding happened before the wrong authority. At which point is when they realize, oh, okay, we were really knocking on the wrong doors. And in terms of the respondents, sometimes they go to courts because they feel that the recommendations are disproportionate, or that they feel that the recommendations have not been thought through. They have not taken into account, the IC has not taken into account all the evidence that was brought before it. And we also see the ICs sometimes want to do a lot of good to the survivor and stand by that person. And in that over enthusiasm, things, the law and procedure just go out of the window, which just makes it very difficult for both parties. Yeah.
Thank you, Purna. Very insightful. Just a follow-up question for Soumya on this. Do you see situations where parties approach courts because they feel the inquiry process itself was unfair, rather than because they disagree with the conclusion? Or is it the other way around? Or is it both?
Yeah, interesting way of putting it, I suppose. I would rather say it's the outcome of an inquiry is what concerns the most. Because I think it is either who the complainant or the respondent, either of them feeling unhappy or unheard. So it's then that the appeal goes, right? If they're feeling heard and if their questions answered, I don't think they will go whether the report, they've followed the process, not followed the process. None of these things matter because they don't know the process, right? If they have felt heard, there's no grievance then. So whether it's the complainant or the respondent, they must feel that they have got justice. Even the respondent that way, if they feel that you have heard me, there's a complaint against me, but you have heard me. I got all my chances, and there are reasons as to why you have made a particular, findings or a conclusion. They won't go on an appeal, because if they have felt heard and if they felt that you've handled the matter in a just manner, I don't think people go on an appeal, because I think by now people know that going to any form of court or it's just time consuming. They wouldn't I suppose go to the courts if they have felt being heard. That's the toughest job of the IC, is what I also feel, is to make both parties feel heard and that both of them have got the justice. It's the toughest job. But if they feel it's not the process, I would say it's a general feeling that either both parties get out of the whole process and the final outcome.
Thank you, Soumya. We see judicial scrutiny in POSH matters has definitely increased in the last few years. So, Soumya, in your view, Do you think increased judicial scrutiny has strengthened the implementation of the POSH Act by creating accountability? Or has it made organizations and ICs overly cautious and defensive in handling complaints?
I would say it has strengthened the implementation by making them cautious that courts are watching, I would take it that way. Because when the law came itself, people were already defensive, and it was defensive enough in the sense that, oh, why should we have our own committees, and wouldn't it increase the number of complaints, and wouldn't it, make people file unnecessary complaints or even false complaints? People have been there is always a section of people or workplaces who handle this with a defensive mode. But I consider that because there's judicial scrutiny, there are people going to courts. I think workplaces are following it more seriously and looking at it from a very not just a mandate, but also that I don't want to be questioned later by the courts, or and once there's a good decision that comes up in courts, it's all over the media. People are certainly cautious, and that way implementation has become much more active, is how I would put it.
Puna, anything you want to say? I can see you're like bubbling out there.
No, I agree with Soumya. It's good also because recent Supreme Court judgments have also pulled up, institutions for not complying with the, framework of the Act. And that has also pushed for more, surveys and other processes to better implement it. So I'd also say that I welcome this.
Fantastic. Thank you so much for that. Um, one important question organizations often ask is whether courts treat the internal committee as the primary fact-finding body. So, Puna, this question is for you. When POSH matters come before courts, do judges generally defer to the findings of the internal committee, or do they tend to re-examine the evidence, the whole inquiry process in detail, get into nitty-gritties of it?
No, I don't think courts can even do that. At best, if they find discrepancies, they can perhaps order a re-inquiry or pass an order that pushes the institution to remediate institutionally. But courts necessarily don't have the jurisdiction to look at how the inquiry or what kind of evidence has been gathered, etc. They stick mostly to whether the inquiry adhered to principles of natural justice broadly. And that again, has what are these principles of natural justice also you will not find in the Act or the rules. That's largely been evolved through, Supreme Court jurisprudence. And only if there are grave lapses and there's prima facie, circumstances pointing to an IC which has completely failed to do what it was set up to do, perhaps the court may step in a little bit, but otherwise they're not going to question the IC's the evidentiary value of what has come out in the IC report, at least from whatever I have seen. And if things are very bad, then a re-inquiry or something to remediate at the institutional level is what the courts also have the power to do. They cannot do anything beyond. That would be unconstitutional.
Okay, so then would it be fair to say that the courts are more concerned with the fairness of the process rather than conducting a fresh inquiry into the allegations themselves? Is that?
I would think so. Sorry.
Yeah, go ahead, please.
No, I think so because a lot of these, even the appeal does not go to any trial court, right? Like it goes to your high court. And high court in even a criminal proceeding is not going to sit and say, okay, I'm going to record your statement and bring your mobile phone recording. And so they will at best see if it is a fair trial, or a fair inquiry. And if it's not, then whatever it is within its power to remedy that, either for the respondent or for the survivor, is all it can do.
Thank you.
Yamuna, I would like to add something because it's a very interesting point and very important question, I feel. Because normally when this is mostly, my response is more for the non-lawyers, because when we say appeal, people normally think that, like there'll be re-examination, witnesses will have to go, internal committee members will have to go to the court, and we'll be made to stand in the witness box, and we'll be called to the court, and these kind of things. In fact, even the parties don't go to a appellate authority, right? It's just the lawyers who go to even the appellate authority or even to the courts. An appellate court does not look into evidences. It just looks into the uh, judgment, and in this case, the findings report, and whether the natural justice principles have been followed, whether the process has been followed, whether your report is reasonable, has logic and reasoned. Is it reasoned? Is it reasonable and logical and has followed process? That's all. Probably and through that it will see whether the final report that the internal committee has made, does it, like if you look at the appellate provisions of the POSH Act, so the recommendations, implementation of recommendations, and these are the only very limited, the appeal is. So people bring in all aspects of those. So the recommendations were not reasonable is one of the grounds, primary grounds on which people go to appeal. And the appellate authority will only look at whether the IC has followed these principles or the procedure laid down, and whether the recommendations are reasonable and whether it has been executed. This is what the appellate authority or the courts can look into, and they don't go into evidences. They don't even send personal notices or warrants to internal committee members. And if at all internal committee members receive a notice from an appellate authority or the court, they would be represented by the workplace or the employer's, legal support, and not individually. The internal committee works for the workplace. It's part of the workplace, though it's an independent body that looks into the inquiry, but they're not independently or individually personally liable. So appellate authority, firstly, what I wanted to bring about is that appellate authority does not look into or does not inquire into the matter itself, and parties and witnesses or the IC members are not expected to go there. And secondly, appellate authorities or the courts don't personally make the internal committee members personally liable. These are the two things that I wanted to let the non-lawyers know.
That's a very interesting point, Soumya, because a lot of times, especially after you do an IC orientation, this is a question that comes to me from a lot of IC members, right? They're worried, okay, I'm going to do my job, and then what? When there's an appeal, will they call me to court? Do I have to then stand in the witness box and start talking about, those things? Okay, there are some questions coming up. We will look at your questions at the end of the session in the interest of time, but we'll definitely come to it. Thank you. Keep posting your questions in the chat box and we'll get back to it. Thank you. So thank you for that, Soumya. That is very, very interesting, and that's very, very important what you touched on. And Puna, the points you brought up also is very, very important. Thank you for that. Now let's talk about principles of natural justice. Since you just mentioned principles of natural justice, it is a backbone of every legally sustainable inquiry. So, Soumya, how critical are these principles when determining whether an inquiry withstands judicial scrutiny?
I would say that's the only aspect that's most important. Natural justice principles are to be followed by the internal committee when we do the when we conduct an inquiry, which means that both parties are to be heard uh, equally without any bias, having all equal and fair chances to explain their side of the case. Plus, I would add that the whole process shall be transparent to both parties in the sense that confidentiality is a totally different issue. Transparency of process is a completely, and I would argue that it falls within natural justice principles to keep the process transparent. So, natural justice principles is the key to a good, proper inquiry, even under the law, and it's the most important aspect.
Can either of you, for the benefit of the audience and members who are here, uh, tell us or share with us what do you mean by principles of natural justice? Like which aspects?
Purna, would you want to go ahead fast?
Yeah, and you can surely add. So even in general, law, what is seen as principles of natural justice is that you give both sides, a fair chance to make their case, and that you don't become the judge in your own case, and also that as much as possible decisions are taken only after hearing both sides. You don't do anything ex parte, right? So if there is a member of the IC who's been accused of any kind of sexual misconduct, then that person doesn't get to sit on the IC. And at every stage, from the time you receive the complaint till the inquiry report is prepared, you ensure that both parties know who are the witnesses who have brought them before, what are the documents that have been submitted, what are the statements of the witnesses, is what is the IC relying upon, the timelines. And at every stage, it's like Soumya was saying at the beginning of the session, that the IC should also demonstrate actively that they are interested in hearing your side of the story. It's not just enough to say, yes, I'm impartial. You should win the confidence of both parties that I'm genuinely interested in hearing both of you, and that I have not already made up my mind. So when we get cases, either the survivor says, they had already decided that they want to protect this person, or the respondent says, they had already decided that they wanted to throw me out of my job. So when as an adjudicating body you start off on that foot, then you have not really followed the principles of natural justice. And at every stage, I'd also say that try and put your proceedings on paper. The reason I say this is we have seen specifically in a few cases where the respondents have said, you're supposed to offer a conciliation as a method of resolution. So we don't know if you've done that. Now, is conciliation a mandatory step? Not necessarily. I wouldn't say so. But whatever it is that you're doing, try and record it in writing so that later on you're at least able to establish what all you did as an IC to ensure that both parties have had an equal chance at making their case before the IC. And definitely, we've also seen instances where when an IC member is replaced because they have a complaint against themselves, the person who replaces them is a close friend or somebody who's reporting to them, or somebody who's hired them for the job, so on and so forth, all of which compromise the overall proceedings, and whether or not you are taking the principles of natural justice seriously. And I'd just like to add that there is no great rocket science or some complex formula for natural justice. It's a very intuitive thing. Like, would I want a respondent's friend to be on an IC deciding whether the respondent has done this? Would I want a survivor's friend to sit and say, has the respondent? So it's very intuitive, and That's what I'd put it down to. Yeah.
Thank you so much, Puna. From whatever both of you are saying, one thing that I definitely have taken away till now is documentation is very, very important. Whether it is to show what we have done as an IC, or say goes for an appeal, then for them to see what we have done as an IC. Thank you for that. There are often differing views on procedural safeguards during POSH inquiries. We're talking about principles of natural justice. Puna, maybe you can go first, and then Swami, you can follow on this. Can denial of cross-examination, insufficient opportunity to respond, or failure to share relevant documents and evidence invalidate the inquiry altogether? And if not, then yeah, I'll come up. Sorry, I have lots of questions on this. Go ahead.
Yeah, no, this is a
Get me.
very contentious part of the
Yeah.
IC proceedings, the cross-examination. But I'd say, as a matter of good practice, I'd urge all ICs to actively, make this option known to both parties in writing. Because then we've seen instances where will say, no, you have not told us, and it runs into trouble. So, as a matter of fact, I'd say, just as best practice, please just do it. It's not going to hurt anybody, it's only going to strengthen the process. But having said that, I don't think it is something that I'd say you can claim as a matter of right. Why I'd say that, and I'll substantiate, is because you'll have to see it on a case by case basis, right? What the Act says is principles of natural justice. So, throughout the inquiry process, if you're able to demonstrate that you have given both parties enough number of openings and options to come in and make their case, ask their questions, either of the IC or the witness or the other party, then I think not making this option of cross examination does not really mean that you have not followed principles of natural justice. So, and even then, I'd say, just on the point of cross examination, a whole inquiry cannot fall. Just on the point of cross examination, the whole inquiry does not stand vitiated. But to ICs, if you ask me, I'd say just stick to the law, make it clear and put it in writing. But I'd say it's not something that you can claim as a matter of right when the IC has done everything else to make sure that your side of the story is documented in detail. And on the question of documents, I feel we should speak about what kind of documents, right? So I have been on ICs where they feel like, just sending a gist of the complaint to the respondent is enough, or just, an email saying this is what it is. Those kind of things obviously
Just
does
saying
not
that we
follow
have
principle.
evidence against you, but without sharing the evidence.
Yeah, so those kind of things are a complete no-no. You have to share critical documents like this, and how do you decide what is critical or not is whether that is the document on which the IC is relying to make your recommendations, and whether withholding this piece of document is something that will prejudice the outcome of the inquiry, right? You're not entitled to every document, right? For example, if the one of the parties has been cross examination made, asked for some very personal details of the other person, and it's almost like attacking the character of this person. Now they cannot say, now I've given you this question, you record an answer and you give it to me. If you don't give me the document, then it vitiates the proceedings. You cannot argue like that. So two main things I'd say: is it a document on which the IC is relying to make your recommendation? And is not sharing this going to cause prejudice to the proceedings? In that case, it vitiates. But overall, you have to see the context in terms of cross-examination and conciliation and all of those procedures. Overall context of what the IC has done through the inquiry process needs to be seen to determine whether principles of natural justice were adhered to. You cannot cherry pick some procedural suggestions and say, okay, this has not been done, therefore the whole thing is out of the window. So that's where I stand.
Soumya, you want to follow that up?
Yeah, I completely agree with what Purna has said. I would want to probably add to it or put a couple of things in a different perspective is that, firstly, I think what it's again part of natural justice is that both parties know what the other party has submitted before them. So for the respondent must know what the complaint is, who is the complainant, who are the witnesses, what evidence has been produced in favor of the complainant, by the complainant, or against the respondent, against me. So the respondent should know or get a copy of the whole complaint, all the evidence is produced. Like again, if it is relied upon by the IC to come to a conclusion, certainly yes, I would say whatever has been produced by the complainant and whatever statements have been made by the complainant before the IC has to be shared with the respondent, and whatever witnesses state before the IC is also to be given a copy to both parties, to the respondent and the complainant. Coming to the point of cross-examination, in principle, yes. When I receive a copy of the complaint as a respondent, or when I know what the respondent is replying to my complaint, I should be given an opportunity to ask certain questions or to make a reply or give a reply to the statement of the respondent or to the complainant, to ask certain questions if I don't agree with them. So cross-examination in the sense is not the cross-examination that we see in regular courts, but this is an opportunity for me to reinstate my case or repeat certain, rather support my case or to question the version of the opposite party. So as a complainant, I should be given a chance to give a reply to the respondent or to the witnesses who have gone against me. Or as a respondent, I should be given a chance to raise certain questions which I do not agree with. So the law or the act does not use the word cross-examination. But in principle, it is part of natural justice. Whether the respondent, if the respondent has not got a chance to question certain things that they do not agree with, or if the complainant has not received a copy of a witness statement that goes against them, then certainly the process is not transparent. It is not following natural justice principles. That is, in principle, I've not been given a chance to cross-examine. So in principle, yes, it becomes very, very necessary to make them know that they have a right to receive all these documents and to give their response and to raise any questions to the opposite party or to the witnesses. So I would say, though the law has not specifically used the word cross-examination, and that I also feel is for a reason, because these matters are very sensitive. You can't allow something like a cross-examination that happens in a criminal court or even in a civil court for that matter. There's, like face-to-face cross-examination, shooting questions. That does not happen here and should not happen here. And that's the reason the law has not used the word cross-examination, but natural justice, which means that there has to be transparency in the process. Whatever the opposite party has submitted before the internal committee, I should get a copy of it. Whatever you as internal committee are looking into to come to arrive at the findings, I should know about it, and I should be given a chance to respond to it, the submissions on it. So I would say, yes, it is very, very important to let people, I wouldn't say cross-examine, I would say a chance to respond to the opposite party's claim or case. Yeah.
Thank you, Soumya. So, Soumya, I'm going to continue with my next question for you. What are the most common mistakes made by the internal committee that later result in findings being challenged or set aside by courts? Are these usually substantive issues, or relating to evidence and conclusions, or is it procedural mistakes? Generally, what's
So there are many procedures. I mean, there are many aspects of the procedure that needs to be followed by the IC. But if you ask me what is the one common mistake that probably ICs follow or happen to commit, I would say IC standing on a high pedestal, saying that, okay, I'm kind of quasi-judicial body, and I standing out or standing above everybody, not hearing, not listening to parties. I would say, again, going back to natural justice principles, giving both parties, being accessible to both parties, listening to both parties is very important. I've seen many ICs who have said, oh, why should we give a copy of that? Why should we do this? Why should we listen? Why should we, give a chance? We have already heard the complainant once. There's no necessity. Oh, they should know that. People don't know, right? I mean, people don't know. You have to sit down with both parties. You have to speak to them, both of them. And I've seen many ICs don't do it, or unless the external member coaches them and tells them that we require to do this as part of natural justice principles, ICs don't do it. So the first thing I think the internal committees must do is being open to both parties to present their case. This is what a lot of ICs don't do, and they must do. Listen to both of them, speak to both of them, let them know of their rights and responsibilities, and make a note of it in your report, in your daily report, and do everything and make a note of it. Follow all process, make a note of it. Make a note of it would be the second mistake I would say ICs don't follow. But the first one is to make that genuine effort to speak to both people, like how even Purna mentioned. Speak to both parties, let them know of the process. They don't know what the process is. They'll not have a clue. I have had many aggrieved people. When I'm not part of the internal committee, some aggrieved person, either the complainant or the respondent, coming to me and asking what will happen next. They're speaking to a third party lawyer because their ICs are not telling them. Right. ICs have to sit down, speak to them, and be accessible to them. And the first thing that you tell either the complainant or the respondent is that you can speak to me at any point of time. Ask me any questions. We are here to listen to you, and we will hear both sides. This is the first thing that I think must go to, and this is something that ICs fail to do, is have and note it, make a note of it, saying that this was explained, the process was explained to the complainant, the process was explained to the respondent, they're okay, they would like to explore conciliation. Put down everything in your report, but speak to them and be accessible to them is how I would, yeah.
That's a very valid point, Soumya, because in some companies that I work with, they have templates where it is already captured. All of these points that you just said, right? We spend a good 10 minutes where the SPOC actually says the whole process, talks about confidentiality, talks about how the inquiry proceedings will go, talks about non-retaliation, talks about, the opportunity to cross-examine each other, talks about how they can reach out to anybody. I see, I'm here, all those assurances. And I know some people who will get irritated with that. They say, "Are you're wasting 15 minutes of our time telling this, just give it to them in writing." They get it in writing too. And they also get, it verbally. And then it gets captured in their verbatim statement too. So the first part of the verbatim statement is all that you capture. all that you said, right? And then comes their actual statement to the committee. And it really makes our work easy because I've had cases where it's not captured, their template is very different. And then when we share the findings report, the party has come back saying, but you never told us this. Now I want you to call 20 witnesses.
Yeah,
How
so
to
what I
cross-examine.
would, yeah, totally. So what I would add to that is that not just in the beginning, because in the beginning, it's all a haze. I mean,
Much, yes.
they don't know what's happening. They're coming before you for the first time, and if you tell them confidentiality, non-retaliation, we are going to hear both sides, natural justice principles. I've heard this. I mean, even in mediation processes in the court, the mediators sit down and take half an hour, whereas the complainants or the parties would be so restless to speak to the so
Yes.
even then it does not. So this attitude of the internal committee that we are here to listen to you should be there throughout. Even at the end of it, they might come back to you, like you said, but I never knew of a interim relief, but I never knew of something that, then you should be, I mean, the IC should have the patience to, I mean, repeat the whole thing to them. And yeah, being accessible and explaining all of these, speaking to them, I mean, throughout, I would say throughout. I mean, they would come back to us saying that, how much long will it take? What are you doing now? Why is it taking so much time? So I would say, yeah.
I've had a PO presiding officer who's replied, didn't we already, and the tone was really harsh. He's like, didn't we already explain this right at the beginning? So yeah, what you said does make sense. Yeah. All right. Thank you so much. So Purna, follow-up question again for you is, see, sometimes what appears to be minor procedural lapse, do you think it has any major legal consequences later? Do you have any examples that you can share regarding the same?
Yeah, I mean, one thing that I wanted to add to what Samya was saying also, which is a part of the procedure, she's saying that you should be accessible to both parties, for which first the employees need to know who are the people on your IC. And in a lot of the IC trainings, within the first 10 minutes, I realized nobody has even heard of one member also in the IC. So the first thing is to just project the names and numbers of who's there. So that itself is a very basic thing, which goes on to mess up a lot. If that basic thing is something either the survivor or the respondent knows, they wouldn't be filing complaints before the wrong authority. But anyway, the other things that we have noticed, in terms of what can be challenged in a court of law is, for example, how the IC is constituted. Right, a lot of the organizations don't take the tenure of the IC very seriously. They don't even know that there's a 3-year tenure. So somebody is like sitting on the IC for 6 years, 7 years, and that's clearly an illegal IC. Then we've seen cases where there is a male person who is a chairperson of the IC. These are all very common mistakes that can very, very easily be avoided if only we paid a little bit more attention. Then I have seen instances where the external member is not really an external member. They are a legal counsel in a sister concern, and then they are also on this IC. So nothing is external about any of this, right? And then that brings the independence of the IC into serious question. The other thing is, in terms of the constitution of the IC itself, it's the employer who has to issue this notification saying these 4 members or 5 members have been appointed. A lot of the times, this document trail is itself not there. So you don't know who has instituted this IC, how have you come into existence, how have you added this external member, what is the authority on the basis of which you're holding this inquiry, all of which are all of which are questioned in a court of law. And it's very sad because whichever party has gone to court is suffering the consequences of something that a company can easily kind of rectify. The other thing is the problem of over enthusiastic ICs who take up complaints suo moto, and then yeah, both parties don't know that this is not something they can do. The full inquiries happen, you go to court, and then you're standing there saying, who complained? Nobody complained. How have you done this inquiry? And the question of anonymous complaints. A lot of times I see sit and grapple with this, saying, okay, no, but morally we have received this complaint and we have to do something. What are we supposed to do? Let's call this person who's a friend of a friend who said this happened to my friend, so I will sit and get details. These are not things you can do. Nothing of this is going to add any value to the inquiry itself, let alone an appeal process. We have also seen instances where the ICs finished the inquiry report, and then the party wants to go on appeal, but not all IC members have signed the report. So what is the report that you guys have created? Is the employer bound by it? Can I go on an appeal? And the consequences have also happened, like either the survivors has been thrown out or the respondent has had a salary cut or a demotion, something on this IC report, which has not been signed by all members. And I also feel that ICs take all procedural safeguards. I mean, I think I'm saying this way too many times, but I've seen it way too many times that they take procedure under the act very lightly. So, for example, the respondent is supposed to get a notice of the complaint with all the documents within 7 days of receiving the complaint, and the 10 days, or I think they have a stipulated period of time. But some ICs take forever, and they're trying to make the complaint as strong as possible, all of which A, points to bias. Two, you're not on strong ground when it comes to procedure also. So this problem of over-enthusiastic ICs really is, or either I've seen both ends of it. Either they are very, very active and they want to do everything possible, or they just are like, okay, we'll see, we don't have time this week, we are busy, we'll get back, we find the time to meet. And so you have to take these, you're a quasi-judicial body, and the seriousness of it is something we should be able to convey to members of ICs when we're doing these trainings also. And all of these minor things will just, when it goes on appeal, whatever the ICs decided, it's going to be easily struck down by a court of law. So we must pay attention to what we think is a tiny, my procedural thing. It's a very important part of the inquiry, I'd say. Yeah.
Thanks. Thanks, Puna. That was stated funnily, but I think those are really pearls of wisdom. And I'm sure a lot of people have a lot of takeaways from it. I'm hoping a lot of IC members are listening to it, including employers, because this is very, very pertinent. Let's look at standards of evidence that we look at during inquiries, right? So how should ICs approach cases that rely heavily on, Soumya, this question is for you. How should ICs approach cases that rely heavily on circumstantial evidence, or say even sole testimony of the complainant? Because I know there's a case law, or plenty of case law saying sole testimony of complainant is sufficient if the IC is confident in what she's saying. But throw some light on it, please. How does it work?
Yeah, I would say firstly, yeah, when we know that this is not like a regular criminal code, or even a civil code for that matter, not going behind absolute proofs, but on circumstantial evidence or on probabilities, and not so much on actual evidence, because in most of the cases there will be no actual evidences, and it would be most of the times a set of circumstantial evidences that the ICs will have to rely on. But what does that mean is a very, very difficult question to answer, is how I will say. Also because, circumstances are very different in different cases. So everything put together, is it making sense? So if it is making sense, I wouldn't want to put it in a form of the actual, legal language or the language of the court of speaking of primary evidence and secondary evidence and tertiary evidence. But I would rather say, things like there are primary aspects of facts of a particular case. If the allegations are that I left office at a particular point of time and I was molested on the way back home when I was dropped by a colleague. If this is the firstly, the main facts of the particular case are to be taken into consideration and to be seen whether that was probable. And if there are inconsistencies in this narrative that the complainant is giving, when there are when the defense or when the respondent puts forth their case where they're defending themselves, which part of it is making sense, and is it all coming together or not coming together? And in all of these cases, yeah, like I said, there are different aspects. So both sides of the case, important pointers of both sides of the case, and is that making sense, or is there a reason that you can attach to these narratives, and which is more probable, and which is the circumstance which is more probable, is how we'll have to look at as an IC. I would say, the first set of circumstances that the ICs will have to look at is the primary set of facts that the complainant gives, and then the match it with the primary set of response that the respondent gives, and then go into the additional circumstances where either the complainant or the respondent says things like, I called this person within half an hour. So that person becomes the important witness. ICs must speak to them. So whoever is being named by either the complainant or the respondent, who falls within this set of points or the important facts, within the case of the complainant or the respondent, they have to be spoken to. Those evidences will have to be seen. For example, if the complainant states that while we were going, we had to stop halfway through because the respondent stopped the car, for example, then during that same time, I tried to book a taxi. If that was, then that becomes the second set of things that where you will see whether, they tried to book a taxi during that time. So make a list in your head of what are the important things that you need to look into. And then what are the secondary things that you need to look into, and speak to everybody possible who will put into the whole case certain things that will make you easier to formulate your findings. And then, a collective thinking process will have to go into this, where, you debate it out. There have been several, you would know, also instances where, ICs literally kind of argue out with each other. There's so many fights that go, we take long hours in these cases where we discuss matters and circumstances coming together to give you an idea of the probability of the scenario. I would put it in that way. Yeah.
Thank you. Puna, anything you want to add to this?
No.
Thank you. So, Puna, before we wind up, because I'm also keeping an eye on the time, see, I've dealt cases where various parties to the proceedings showed minor inconsistencies in their statements. So, how do courts view such inconsistencies in statements, if at all?
Yeah, I mean, from my experience, I don't think courts go into the statements of either parties, the witnesses. They don't in appeal appreciate the evidence at that level. What they're looking at is overall, has the inquiry happened in a just manner? So I keep my response very brief to that I have personally at least not come across cases where courts have said, okay, but on this day you said this, the next day you said this, they are not congruent. But I suppose maybe Soumya can also come in on this if you feel that, there have been instances where the courts have gone into this aspect.
I agree with Purna. I don't think courts go into these sort of things, but like I said, if it is all recorded in writing properly through a report as to, what are the aspects that the IC has looked into in coming to that set of findings, and if it is looking reasonable, reasoned out, logical, and is not very disproportionate to the set of this is what the appellate authorities or the courts look into, whether whether you're making too much of high-handed statements, or is your procedure followed basic, is it reasonable, have you recorded everything, have you given both parties the required chances, and 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 is your recommendation appropriate or proportional to the kind of misconduct that you have found probable. I think that's what the courts look into.
Yeah.
So before we end today's discussion, I have a rapid fire question session for you all. Please keep it brief in the interest of time, because we also need to look at some questions from the audience. If I think there was one that popped up. I don't know if there are more. So Purna, you go first. Soumya, you can state after Purna. One judgment every IC member must read.
I'd say Vishakha because I think IC members should also be able to locate the context, the social context of gender-based violence in India, which is where a lot of ICs also falter. It's not just a law; there's a social context to GBV. So yeah.
I would also say Vishakha.
No cheating, Soumya. Sorry. That's taken. That book was a single edition and it's gone.
Yeah, no, also, the context of the whole thing, because judgments can keep coming, right? Judgments can keep coming. So I would also say not to rely too heavily on judgments, because that can change. Follow Vishakha, follow the act, follow the principles laid down in the act more than enough. If you want me to give another answer, I would say Aurelio Fernandez, because that's reinstating Vishakha.
Okay, one procedural safeguard that is absolutely non-negotiable.
How you choose your external member. Should be really external, should either have know-how of law or should have a social work background. Choose your external members carefully.
Procedural, I would say natural justice principles and documenting it well.
Okay. What is one common myth or misconception about POSH litigation that organizations should stop believing?
That if they put their weight behind the aggrieved party, their reputation is going to be diminished, that their organization will lose something by standing by the person who's been aggrieved, whoever it is.
Thank you. Soumya?
Yeah, I would say that the IC members will be, will have to face litigation.
Back to court.
have to answer the court. Do we have to go to the police station? Do we have to go to the court? This is something that, no, you're not that important.
All right. Two more and then we're good to go. What is one common mistake you continue to see organizations making repeatedly in implementation of POSH or in inquiries?
I think the trainings, they still continue to see it as a checklist. Like you just tick it. So they say 1 hour there, you just come and do whatever you can. You need to take the trainings more seriously.
Purna, at least they're saying come and do. I just heard recently that or she would come, the external member would come and sign on a register to show that she's conducted something, but she was not really conducting
God.
anything. I was appalled when I heard it. Yeah, Soumya, your turn.
Yeah, I think people still don't put it up on their notice boards of there being a IC and who can contact. And people have this, oh, I'm going to put my number, I'm going to put my email ID on the notice board. And I think it's very, very important to put it up on the notice board, not just on your intranet. Put it up on the notice board, put it up on your website as well, please. And yes, that's highly important.
In all languages, if you can.
In
all languages, absolutely.
Yeah. So as we come to the close of today's discussion, I would like to thank both our panelists, Poorna Ravishankar and Soumya Bhatt, for sharing such thoughtful, practical, and legally nuanced insights with all of us. Today's conversation clearly highlighted that POSH compliance is not merely about completing a statutory requirement or conducting an inquiry mechanically. Courts are increasingly reminding organizations that fairness, sensitivity, procedural integrity, and accountability are central to every inquiry process. What also emerged very strongly from this discussion is that internal committees are not expected to function like criminal courts, but they are expected to function responsibly, fairly, and in accordance with the principles of natural justice. Documentation, neutrality, timely action, empathetic listening, reasoned findings are no longer optional. They are essential for building trust and ensuring that inquiry outcomes can withstand scrutiny. For organizations and IC members joining us today, I hope this session encourages you to move beyond a checkbox approach to, for your POSH implementation, and instead focus on creating processes that are legally sound, humane, and credible for everyone involved. Thank you once again to our wonderful panelists, and thank you all participants for being such an engaging audience. I know there's some questions that have popped up. At this point, because of time, we cannot take it most probably. We will get back to you over email. Please drop us an email. You can write to yamuna@sashaindia.com or soumya@sashaindia.com. Poorna, I'm sorry, I cannot remember your email ID. Please.
No, I will put my email on the chat.
Perfect. So we truly hope today's discussion has given you valuable perspectives and practical takeaways that you can carry back into your organizations and inquiry processes. We look forward to seeing you again in our upcoming session as we continue to explore important conversations around workplace, dignity, inclusion, and safe working environments. Have a wonderful evening, everyone, and thank you once again for joining us today. Thank you all.
Thank you, Yamuna.
Thank you.
Thanks, Poorna, and thank you all.
Thank you so much.
Thank you to all. Thanks.